Next matter I'll call up is 2013-330, State of Arkansas versus Wayne Moats. Or to make the appointment of the Public Defender's Office. Mr. Moats is for arraignment on arraignment on charges of inducing a controlled substance to the body of another, a Class Y felony.
Enter a plea of not guilty, Your Honor. Waive formal reading of the charges.
This case will be set down for, by scheduling order, this case will be set for trial in July with an expiry appearance date of April 3rd. And there'll be a written scheduling order that reflect those dates. Is there any other matters to be taken up at this time?
Your Honor, I'd like to address the issue of bond.
Okay.
Your Honor, I believe that his bond has been set. Is it $15,000? Is that what the court reflects?
That's what the file reflects, yes.
Your Honor, this is a case, and we're going to have a companion case involving his wife, Stephanie. It's going to be in front of you in a few minutes. This gentleman is 41 years old. His only criminal history would be various misdemeanors. He has no felonies. The house where this took place at, Your Honor, Mr. and Ms. Moats had only been residing there one day. And I understand that this is a very serious charge, but this was not their home. He does have a place that he can go and live, and that would be with Joe and Carlene Jones, who live here in the Mountain Home area, 298 County Road 632. He is a former correctional officer, worked with the Department of Corrections from 1991 to 1999. Again, Your Honor, not discounting the nature of the charge and the amount of publicity it's received, but we'd ask for a substantial reduction in his bond.
Judge, he has this charge pending. He also has case 13270.
270 something.
Has another charge pending. I think he's drug related as well.
It's the same charge.
I think the child has been removed from the home, but the child was their child and tested positive for methamphetamine. There was a lot of drug paraphernalia there at the time of the arrest.
This was all the same day.
I feel that this gentleman is in a position which he has an addiction, and if he gets out of jail without addressing his addiction, I think he'll be right back to this, because he always has a couple of cases pending, and it's escalated, and now it's involved an innocent party, and what people put it ingest in their body is concern to the state because of the consequences that can happen, but it gets more serious when children get involved.
You know, I believe that all the incidents that Mr. Kincaid refers to occurred on the same date and from the same series of arrests. We're not talking about a pattern of crimes that went over for several days or several weeks, one day. Again, we would ask for a substantial reduction in his bond from $15,000.
November 4th was the day. They came back a month and a half later and had new charges.
Well, reviewing the record, it appears that it appears that the defendant is alleged to have resisted arrest on the original occasion, which also involved charges of endangering the welfare of a minor.
Just the same day.
I understand that it all came out of the same incident, but at this time the court feels that the bond is reasonable based on the nature of the charges and the serious nature of them. basis, the court's going to leave the bond at $15,000.